In 1984, the U.S. Supreme Court decided a case called Strickland versus Washington. And they said that defendants in criminal cases have the right to counsel under the Sixth Amendment. And obviously the right to counsel doesn't mean anything unless it's effective. And so if you're denied effective assistance of counsel at trial, then you're entitled to relief. What do you have to show? Well, first of all, you have to show that the representation of the lawyer fell below an objective standard of reasonableness. And that's the burden of the defendant. And secondly, and it's now turning out most importantly, you've got to show prejudice. You have to show a reasonable probability of a different result. More likely than not that there would have been a different result.
So I want to talk about a case that we recently handled, and I got a call from a colleague, and she mentioned that one of her clients, she's a therapist, one of her clients had just came back from court and directly to her office, and she was concerned that this kid did not know what had happened in court. And so I asked a couple questions, and through our conversation and through conversations with the family, we figured out that the child was about 13 and a half, that he had a full-scale IQ of 66, that he was suffering from lead poisoning, and he had brain damage as a result, and he continued to have that lead poisoning. They couldn't get it out of his body, so he continued to suffer from that. He had been in special ed from the time that he started in school, and I found that the court hearing that they had just returned from when they met with the therapist was an admission he had already pled. The family explained to me that when they took they had all voluminous amounts of mental health and medical records on their kid, and they presented all of these records: the lead poisoning, the assessments, the brain damage, and they presented that all to the lawyer. And the lawyer said, I don't want to see that. Don't show it to me. You just show it to the probation department when you meet with them in a couple weeks. So as a result, no assessment was done, no determination about whether or not the minor was competent to have waived at any stage the potential uses of that information, both from a mitigation standpoint, but also from potentially as a potential defense to the case. None of that was explored by the lawyer. When I opened up the police report, the first page of the police report had as you all know, the booking sheet had a witness right on the first page with address and contact information. We looked at the police report, and the witness corroborated everything that our client said, and said the exact opposite of what the victim had said. So it's clearly an exculpatory witness, and no one had ever contacted that witness, ever.
Though in recent years I've spent much more of my time dealing with adult criminal justice matters and providing defense services, my sense from what I have kept up with in the juvenile court is that the implementation of the right to counsel in juvenile courts, much as it is in misdemeanor and lower courts in this country, is still very much of a problem. Funding everywhere remains an enormous problem, and the lack of adequate funding, and as I will suggest, structure of defense services as well, lead to a wide variety of difficulties. Here in LA County, as mentioned several times this morning, and I'm not going to dwell on it because it has been well covered, you have these flat fee contracts that typically go to the lowest bidder among private lawyers. And they are an enormous disincentive to do all of the work that is necessary. I don't suggest that all private lawyers are going to do the bare minimum because they've signed a flat fee contract. But I have not the slightest doubt that there is an enormous risk that many of them will do far less than what they ought to do, and they are only doing what lawyers and other people in our society do when the compensation is frozen and it's inadequate to begin with.
One of the scariest things to see is a private attorney who's never been in juvenile court show up in juvenile court and try to represent a client, especially when they get $319 a case. I spent half that much on cabs getting to and from here from the hotel. Anyway, so why might juvenile court be a breeding ground for wrongful convictions? And this is more of a think piece. I don't know how many wrongful convictions there are in juvenile court, but I would bet that there are many more wrongful convictions in juvenile court than I can even contemplate. And part of it is because it's a plea-driven court, and part of it's because it's a court that is still stuck in the pre-Galt days, often ruled by a powerful juvenile court judge, where everybody is trying to get together and figure out what's in the best interests of a child, instead of doing client-centered and client-directed representation. But we also know that juveniles have particular vulnerabilities that make them more likely to falsely confess to crimes they didn't commit. And as anybody who's worked on cases in juvenile court know, most of our clients confess. They usually do so outside the presence of their parents or a guardian. They usually do so after being exposed to the same kinds of tactics that police officers use with adults. And pretrial motion practice in juvenile court is something that is not uniformly followed around the country. You're more likely to get it if you have a public defender than you will a private attorney or a contract attorney. But lawyers who practice in juvenile court don't know about Haley and Gallegos and Galt and now JDB and the whole body of case law that talks about special protections for juveniles during police interrogations. If you litigate these cases as if you're dealing with an adult, you have iced out some of the most powerful precedent that exists. Kids are developmentally different than adults. It makes them less competent trial defendants. Lawyers in juvenile court have to spend more time with their clients than lawyers in adult court. They have to explain things in greater detail. And sometimes they need the help of experts to do it because we don't necessarily know how to communicate effectively with our clients, especially if they have developmental disabilities. So you need more time, you need more expertise, you need to know about adolescent development, and you need help. And you can't be afraid to ask for it. You can't do that on $319 a case.
And so what we did was we said that if you wanted to practice in juvenile court, you had to be in the district court for a year. You had to not have any complaints. And you also had to display a commitment to juvenile delinquency law and to indigent defense in order to get that certification. So we created this greater certification for juvenile attorneys to practice in Massachusetts. And then my boss tasked me with recertifying all of the attorneys that practice in Massachusetts. So over the next 3 years, I will recertify. We have 2 levels of representation. We have the delinquency attorneys who represent the misdemeanor charges, and we have the YO attorneys that represent the felony charges. So I am going to recertify all of those attorneys. Now, the one thing that I have in Massachusetts that's great is I have data. All of our attorneys to bill for their services. Now, I'm going to back up for a minute. I'm going to tell you what we have in Massachusetts. We have the right to a jury trial in Massachusetts. So even on a charge of disturbing lawful assembly, I can take that to a jury. I also have the right of appeal in Massachusetts. And so that's very exciting. My attorneys are paid by hour, and they submit bills, and they have to enunciate on their bills how they spent those hours. And so I can take that data and see how often they see their clients. When I'm doing my recertification, I can see how many times they visit their clients per year, and their number of clients, how long those visits are. There are many, many items of performance that I can oversee through